All rise. Hear ye, hear. The Court of Appeals for the First District of Texas is now in session. Pursuant to adjournment, God save the Constitution, this honorable court.
Unfortunately, we can't lower these flags to half mast, but I'd like to join me in a moment of silence in honor of the 21 people, innocent souls, who died yesterday in Uvalde. Thank you. Please be seated. We have one case on today's docket. I will ask for appearance of counsel. The case is, now we'll read short forms of this, but it's 01-17-00822CV, Hassel Construction Co., derivatively by and through shareholder Royce Hassel and other parties, versus Springwoods Realty Company, etc. May I have appearance on behalf of the appellant, please?
Your Honor, Cecilia Hassel.
And on behalf of the appellee?
Your Honor, my name is Tim McDaniel. I represent the Springwoods entities, and I'll just refer to it as Springwoods.
My name is Kelly Conklin. I also represent the Springwoods entities.
And will you be arguing as well? Or?
Yeah, Mr. McDaniel will be arguing.
So I understand that.
Your Honor, Alex Bell for appellee Walter B. Moore.
Okay, so your appellant, you're going to go for 15 minutes?
We're going to
20.
do 10 and 10.
10 and 10.
Your Honor, 10 minutes for me.
5 minutes for you, Your Honor.
Okay, so 10 minutes, 10 minutes, 5 minutes, then back to you for 10.
We gave him 20, do they know that?
All right, then there's another, then we go back over here for another
2.5.
2.5, 2.5. Okay. Do we have all that, Ms. Rack?
And we have some other counsel present also.
My name is John Cahill. I'm here on behalf of Costello Inc., but I defer to counsel Moore.
Okay.
I'm Christine Wilkie. I'm here for Harris County Improvement District Number 18, also deferring for argument to Mr.
Okay. Heavy load you have. So I understand that there were some pages that oral argument exhibits that you wanted to have displayed.
Your Honor, I had responded to a motion on jurisdiction on a couple of days ago, and one of the exhibits to that has a typo, and so I was just going to show it's very easily identifiable, so I don't need to have it on the screen.
Okay, and so what is this on our screens here?
So it would be exhibit 3, excuse me, I think it's exhibit 3 to the motion for extension of time to respond on the partial dismissal motion.
It's a bankruptcy's flow chart for jurisdictional.
Yes.
And is this part of the record, or is this merely a demonstrative that is derived from things in the record?
It is demonstrative of many things derived. Not all the bankruptcies are in the record. The numbers on there are from Pacer. The numbers on the charter at Pacer. Just talk about, I mean,
Well, right now we're just trying to sort through whether we have this on the screen and whether you can refer to it. Are there objections to the use of this demonstrative? Have you seen it before?
Yes, Your Honor, I have seen it. I don't have any objections to the use of it. Very much object to its accuracy and probative value.
Well, that's a different issue.
Same for Walter B. Moore, Your Honor.
Okay. All right, then you can refer to this demonstrative aid during the course of oral argument. And are there any other things that are intend to show or use? Okay. All right, Ms. Hassel, you may proceed.
Good afternoon, Your Honors, and may it please the Court. I was going to briefly address the jurisdictional issues that arose and the one that we've had pending with the Court as far as having notified of pending bankruptcies. The document that was attached to the motion to strike, motion for partial striking, is a document that was signed during pending bankruptcy cases, and that was my intention to show just that there have been 7 related bankruptcy cases which have resulted from the events, and they overlap each other somewhat, and so the chart is also related to the notice that was filed by Ms. Erin Jones with regard to the Chapter 11 case of Royce Hassel, which is still pending. So,
Are you asking us to take judicial notice of it, or is it part of the record, or?
it's a judicial notice. If you would like to, I would imagine you might want to brief I asked to brief this issue after oral argument, so I can brief it further, but I just wanted to note that there is a pending bankruptcy of Royce Hassel, and he's, the case is Royce Hassel derivatively for Hassel Construction Company, Inc. And so,
I have a question about a derivative action. Usually when I've encountered a derivative action, it's filed by a shareholder against the other directors, shareholder or director against the other shareholders or directors. And I don't recall ever seeing one where it's against the third party like this. Do you have any case law to support this procedural device?
yes, Your Honor, I don't have it off the top of my head, but the law changed. The law changed effective September 1st of 2019. Previous to the law changing, right now, derivative actions can only be brought against corporate directors and owners, but previous to that, derivative owners of closely held corporations could sue third parties. And this suit, derivatively against third parties, was brought prior to the law change.
I have a standing question with respect to that. Does Mr. Hassel have standing to file a derivative claim? I understand there's allegations that he is not a shareholder at the time that this lawsuit was instituted. So putting aside, and I'll go back to the original order in the second lawsuit, why does he have standing, even if it's a proper claim, to sue derivatively on behalf of HCCI?
He is a shareholder, Your Honor. He has never lost shareholder status. That's one of the issues that occurred in this case when there was a purported buyout. He has not lost shareholder status at any time.
Is that being litigated in the adversary proceeding?
Yes, Your Honor, it is.
Okay, so we don't have any conclusive ruling on that issue.
That's correct. If you have any additional jurisdictional questions, then I'll just move on to that.
I do. If I understand correctly, and I know you've asked for time to brief this issue, but your position is the settlement agreement and the order of dismissal filed in what we call the second lawsuit is void or is improper because it was entered during a bankruptcy stay. If we set that aside, I know you have some procedural concerns about that settlement agreement of the order of dismissal, but doesn't that order of dismissal in effect foreclose HCCI's derivative claims in this appeal?
Your Honor, our position is that agreement settles matters that are not in dispute in this case. It is what I would call a sham settlement whereby one of the owners of HCCI has received a very large payment in order to make disparate remarks about another HCCI shareholder, as well as the validity of the claims.
But that's a collateral attack on the order, but the order itself and the settlement agreement. And I understand I'm not setting those challenges aside, but if we take the order and the settlement agreement, which is outside the record, which we'll need to discuss as well, does that bar the claims, not RHC's and RHV's claims in this appeal? Does it bar HCCI's claims in this appeal?
No, Your Honor, because it creates more issues and more causes of action for HCCI rather than bar them, because it contains a payment for representations that are simply not true. And it is being litigated in the bankruptcy court whether or not there is a shareholder status, and that issue is now scheduled for settlement, for a mediation. But the agreement contains a lot of other things that they're purporting to settle, including, and makes representations that they're purporting to settle claims that there are no outstanding claims by anyone else. And I mean, it's just, I don't know, the agreement would have to be, it's not attached, I don't believe, to the dismissal order. The dismissal order is based on the representation of the parties that they've settled. And so what that settlement consists of, we say, is not related to the claims that are being asserted in this case.
Have you challenged the settlement agreement or the final order that was entered in the second lawsuit in the adversary proceeding or in any proceeding? And by you, I mean RHC, RHB, and HCCI.
Your Honor, we were not provided that agreement and did not, we had challenged the right of an agreement to be entered in that case by filing a Rule 39 notice that the parties in that case are not representing the interests of the parties in this case. And that was filed long before the purported settlement that's taken place in that case. So that's another thing, that because of the bankruptcy stay and because the order was entered apparently on the 10th of July after a notice was put into the trial court on the 3rd of July, and the case was apparently placed on abatement status. There's a lot of questions, but there's not been, because of abatement statuses, there's not been an opportunity to challenge that. Or the fact that the Rule 30, the 39 notice was not responded to.
I'm sorry, you're saying the second lawsuit was abated?
Yes.
I do see that there was a suggestion of bankruptcy filed on July 3rd, and that was for the bankruptcy that was filed by RHC and RHB. HCCI did not file for bankruptcy. And as I understand it, RHC and RHB were not parties to the second lawsuit. So I guess my question is, did the trial court in the second lawsuit abate the proceedings based on the suggestion of bankruptcy?
The status shows on bankruptcy status in the clerk's office as of the 3rd, but there was another bankruptcy case filed in March of 2018 by Mr. Hassel, the very same person who has signed the RSA, and it was pending even before the June 29th and July 30th bankruptcies of the R. Hassel companies.
You can continue if you want to.
Thank you. Your Honors, the appellees bear the burden of showing that there are no genuine issues of material fact under which they're entitled to limitations summary judgment. The court examines, on review, the court examines the entire record in light most favorable to the non-movement and indulging every inference and resolving any doubt against the movements. And no presumption of correctness applies to the summary judgment. The appellant raised several reasons why, even if limitations had accrued, limitations should not apply, including fraud and estoppel. offenses. And they raised material fact issues on those.
I see your time has expired, so I guess we can hear from Mr. McDaniel now, and then we will hear from you again.
Thank you, Your Honors. Please the court. Again, my name is Tim McDaniel, and just for clarity, the district has ceded its time to me. Costello has likewise ceded its time to me, provided that I remind the court that Judge Moore signed an order of non-suit at the trial court level, so Costello was out and should not be a party on appeal. And we've already talked about the allocation of time between myself and Walter P. Moore. My goal in this very short period of time that I had was to provide a framework for the court to address the statute of limitations issues in this case. To me, the first step in that process is to look and see what the claims are at the trial court level and what was filed. And for that, we look to the plaintiff's original petition and 2 supplements that were filed. In the plaintiff's original petition, they basically allege claims for breach of the Springwoods contract. And I'm going to refer to those as the contract claims. And then they allege everything else, and I'm going to refer to those as the non-contract claims. They also filed a supplement in response to our motion for summary judgment. The first supplement said that statute of limitations was told as a result of the pendency of the first lawsuit. So we've been talking about the second lawsuit previously, but during the pendency of the first lawsuit that was ultimately non-suited on the eve of the summary judgment hearings in that case.
Mr. McDaniel, before you get into the merits of the statute of limitations issue, can you address the jurisdictional question? What impact, if any, does the order of dismissal in the second lawsuit have on the claims asserted in this case, both the fraud claims and the contract claims and non-contract claims? Hold on a second. Not on HCCI, but on RHB and RHC here.
I believe that the settlement agreement has the effect of resolving all of the derivative claims or claims that are asserted either on behalf of Hassel Construction Company, HCCI, or derivatively on behalf of HCCI. I don't think it has any effect on the remaining claims by the other appellants. They were not parties to the second case. They're not parties to the settlement agreement. I think those claims were not affected by the settlement.
Okay, and that pertains to both the contractual claims and the non-contractual claims.
So anything that's through Hassel Construction Company, which includes the contract claims, as well as all of the non-contract claims, because the way they alleged these claims in the original petition, they said they identified all the parties, and then they say plaintiffs sue for assumption, or plaintiffs sue for unjust enrichment, or whatever the claim was. There's a whole litany of them there. So the petition doesn't break it out.
Okay.
But the claims, to the extent that they are asserted either on behalf of or derivatively for Hassel Construction Company, I think are resolved by the settlement agreement.
So to the extent that RHB or RHC are claiming unjust enrichment, Quantum Marriott claims, do you think those are foreclosed by the second order, or the order in the second lawsuit?
If those are the claims on behalf of or for HCCI, but not otherwise. So even with the settlement agreement and the dismissal with prejudice of the first lawsuit, we still have some remaining claims to deal with. And so with respect to those claims, then we're looking at the trial court level to see what the claims were. We have the contract claims, non-contract claims, and the first supplement that was filed 7 days before the summary judgment hearing that said that limitations was told during the pendency of the first lawsuit. The plaintiffs also filed a second supplement well after the hearing on the motion for summary judgment. And in that second supplement, they alleged that statute of limitations is told by the discovery rule. The discovery rule issue was not alleged in a timely manner. It was not before Judge Moore properly. And I believe that issue is not before this court and has not been properly asserted at this court. If you go back and are reviewing the summary judgment de novo, you have to look and see what Judge Moore was looking at and what he could properly consider. He could properly consider the petition, he could properly consider our motion, and he could properly consider the first supplement, but not the second supplement.
So when was the second supplement filed again?
The second supplement was filed on May 22, 2017, and the hearing was actually on April 28, 2017.
So it was after the, and was it, in the supplement, did it amend the petition, or was it just a?
It was styled a supplement.
A supplement to what?
A supplement to the original petition, I presume. Now, we have copies of it. I believe it's styled supplement to the original petition. Now, in our motion for summary judgment, we anticipated that they would make the claim that limitations was told by the first lawsuit. So we actually addressed that issue in our motion for summary judgment. So that issue was properly before Judge Moore and properly decided by Judge Moore.
As to the contractual claims, do you agree that the contract is a continuing contract, so that notwithstanding tolling, you know, there's a continuing accrual depending on the payment claims that were being submitted under the contract?
Well, 2 points on that, Your Honor. One, the Texas Supreme Court has not recognized this continuing contract concept. And so I believe that where we are now with the Texas Supreme Court is the legal injury rule is what is applied, subject to recognized tolling theories. However, if the law of continuing contracts applies, I think construction contracts and the courts of appeals that have addressed it have held that construction contracts can be treated as a continuing contract. So the issue here is, one, what will the Texas Supreme Court do? But secondly, and more importantly, and what happened in this case, is that the parties agreed that there would be a specific condition precedent to the filing of a lawsuit, and that was the contractual mechanism that was put in place. So with that, let me get up to my point there so I can specifically cite the contract provisions. Here, and if you look at the cases, the Milgard case, Honeywell cases, the parties can take the contract, the claim out of this continuing contract if they, one, agree to a specific condition precedent, and two, if that occurs, then the breach, cause of action for breach of contract accrues and statute of limitations begins to run. So in this case, the parties had a specific dispute recognition or mechanism in the case. The claim was submitted to the engineer. The engineer was then given 30 days to decide the claim, either accept it, deny it, and if there's no ruling in 30 days, it was deemed denied. That decision became final unless during the following 30 days, the aggrieved party gives notice of mediation. That was in fact given in this case, and in fact a mediation took place on July 2nd, 2012. The dispute was not resolved there. The contract goes on to say that if the dispute is not resolved by mediation, then the engineer's determination becomes final unless a party gives notice of intent to file a lawsuit. And indeed, a lawsuit was filed, the first lawsuit that was filed, and I believe the date was July 26th, reflecting the Hassell's clear understanding that statute of limitations began to run after the mediation and after the dispute resolution process was exhausted.
Can you talk about the fraud claims? As the movement on the motion for summary judgment on limitations, there seems to be some issue as what is the fraud, when was it perpetrated, and when did they discover it? Springwoods had the burden to establish that date. So what do you think is the fraud, when was it perpetrated, and when was it discovered by the appellant?
So one, we deny that any fraud was perpetrated, but fraud claims are governed by the legal injury rule, and which says that the claims begin to accrue when facts give rise to a cause of action, whether the plaintiff knows about it or not. In the context of a fraud claim, the party can say, assert the discovery rule and say, oh, I didn't discover my injury. The discovery rule is not a point of discovering the cause of action. It's discovering the injury. And in this case, there is no dispute whatsoever that the injury was, or alleged injury was discovered well before the first suit was filed. And they specifically saw damages in the first suit. And when you look at the admissions in this case, Royce Hassel specifically alleged in the petition in this case that they were aware of the damages from the Royce Hassel companies at the time the first lawsuit was filed. A specific judicial admission on that point. So from a legal injury standpoint, regardless of whether it's fraud, conspiracy, breach of contract, it doesn't matter. The cause of action accrued and statute of limitations began to run, certainly by not later than the filing of the first lawsuit. I believe that it actually began to run sometime by not later than the fall of 2011. But in any event, wherever you pick a date, it can't be after the filing of the
I'm
first
sorry,
lawsuit.
the judicial admission you pointed to is where in the record?
Let's see, it's on page, let me find it here. It's on page 22 of the original petition in this case. So the first admission is when they filed the first lawsuit and they alleged that all conditions preceding had occurred. The second time is on paragraph 22, where they allege in this case, when the lawsuit was filed, referring to the first lawsuit, RHC and HCCI knew that the damages included significant costs incurred by RHC. They admit the actual discovery of their injury and hence the running of the statute of limitations from that time. Thank you.
Any further questions from the panel? Mr. Bell, you may proceed.
Thank you, Your Honor, and may it please the court. My name is Alex Bell. I represent the appellees from Walter P. Moore. First, I just want to spend a little bit of time talking about Walter P. Moore's role here because they do have a summary judgment basis that is different than just statute of limitations and that was not briefed or contested by the appellant. So in this case, Walter P. Moore had a contract with the Harris County Improvement District number 18 to design some of the improvements for this project. And so when this third lawsuit was filed, the appellants sued Walter P. Moore directly for breach of contract. And so because there was no contract, Walter P. Moore at the trial court moved for summary judgment on that ground, on the lack of a contract. And the summary judgment was granted without stating the basis. So Walter P. Moore adopted and moved on all of the grounds moved forward by Springwood, so it's all the statute of limitations ground, as well as that additional breach of contract ground, which has not been challenged. So regardless of the outcome on the statute of limitations issues here, Walter P. Moore's dismissal of the contractual claim should stand. They haven't been contested.
So Moore was not in contractual privity with Hassel?
Correct, Your Honor. There was only a contract with the Harris County Improvement District number 18. And so in the absence of a contract, it's black letter law. No contract, no breach of contract, cause of action. So for that reason, that the breach of contract dismissal should be affirmed as to Walter P. Moore. I do have one or two things to add on Springwood's arguments regarding the statute of limitations issues. First of all, on the continuing contract issue, I believe there's a good Fifth Circuit case that addresses a situation very similar to this. It's Milgard versus McKee/Mays. It's 831 F. 2nd 88 at pages 90 through 91. And so it's addressing in-diversity Texas case law. And what it says about the continuing contract issue is that it provides an option of an earlier time to sue than the end of the lawsuit. And if you have an earlier time that you're allowed to sue and you take advantage of it, that doesn't have any effect on the statute of limitations running. And so what does that mean? If you choose to sue earlier in the suit when your cause of action actually accrues, if you have a continuing contract, you can't come back later and claim the later statute of limitations, right? So they've effectively made their choice about when to sue by filing the lawsuit in July of 2012. And so the situation the Fifth Circuit was addressing in that case was one like this, where the real issue and dispute between the parties was the repudiation of the change order. They had applied for extra costs, they had made a bunch of claims, and those were officially rejected at the July 2nd mediation. Now, there's also an exhibit that adds some color to this that the appellant had added for the oral argument today. It's not in the record, but
No, let's not discuss it.
Okay. Anyways, so the record is replete with evidence from both the plaintiff's pleadings and the affidavit of Mr. Hassel that all state that these issues were known when they first applied for the change order sometime in January of 2012, right? The statements are that there were a number of different drawings that were coming along, and the volume of the different drawings was so much that it was going to financially impact them, which is what caused this whole series of events to be set in motion. Now, what they weren't doing was suing on any missed monthly payments, right? So their contractual allowance that they already had was already being paid. The only allegation in any of the three suits that one of those continuing contract payments was missed was in the second Springwood suit that we've been discussing here today. And that was the only claim that survived summary judgment on limitations. And it's because that bill wasn't sent until the end of December. And so that's the only claim that survived a separate look at limitations as to HCCI, and that's the claim that was settled.
So are you saying the monthly payment, with the exception of the second lawsuit, which is the later December payment claim, those payments were being made on a monthly basis, so the disputes was really what I would call extra contractual claims for change orders and additional costs for the project?
Correct, Your Honor, for the changes from the different drawings and things like that. And those differences in the project are the foundation or the basis of their fraud claims and their other extra contractual claims. So their discovery of those and their knowledge after the mediation that they weren't going to get paid for those were the facts giving rise to their right to bring a cause of action, which is how you test for accrual from the Texas Supreme Court. So because those things had all arisen by that time, that's when the statute of limitations ran. It ran no later than when it accrued no later than when they filed the first lawsuit, because if it hadn't accrued, how could they have filed suit? So, the July 2nd mediation is the best date, but it was no later than, the July date of the filing of the first lawsuit.
Well, what about their argument that they had to file the claim because they would have been precluded by the terms of the agreement, that basically the decision would have become final? I mean, Costello's or WPM's decision would have become final had they not instituted the lawsuit. I forget if it was within 30 or 60 days of the mediation.
So the finality of the decision just means that they had to give their intent to file a lawsuit. I don't believe it actually said they had to file a lawsuit. They could have waited until the end of the project and sued for all of these things as well.
So your interpretation of the contract is they should have notified you in writing, they being HCCI, that they had an intent to file a lawsuit, but they didn't have to file the lawsuit under the ADR procedures?
I don't believe they did, Your Honor. I believe they chose to file the lawsuit after realizing that they weren't going to get paid.
So what were they supposed to do to make sure that the decision did not become final, short of filing a lawsuit?
I believe it only required notification that they were going to file a lawsuit, that they were going to challenge the decision beyond mediation. And I did have one last point on the bankruptcy tolling, if Your Honor wanted to hear it, but I see I'm out of time.
You can bring that up when you're back up here for your 2.5 minutes.
Thank you, Your Honor.
Just on that last point, I believe the contract does require a lawsuit to be filed. I would like to respond to some of the other points.
Well, it's fresh on our mind. Why don't we address the Walter P. Moore's point about privity of contract? Your
Honor, the contract requires performance by Walter P. Moore. They are a party to the contract. They are allowed to be sued under the terms of the contract by the owner or the contractor. The contract documents consist of a host of, at the record on page 202 is a specification of what constitutes the contract documents. And it includes many things, but reading the provisions of the contract, it does allow the engineer to be sued. It just says there's some limitations on for what they can be sued. Also, paragraph 9.03 of the contract states that the owner and contractor each bind themselves, their partner successors assigns legal representatives to this agreement, and the representatives of the owners on this project were the engineers. They were acting, they had independent decision making, they were supposed to independently make decisions on the claims, which is one of the things that failed in this case.
And so that would pertain to HCCI. Would you agree that RHB and RHC are not in privity of contract with any of the parties because they're not a party to the contract?
No, Your Honor, I wouldn't agree. I would refer the court to James Construction versus Westlake. It's a case at 594 Southwest 3rd, 722. And in that case, the court begins by saying, and I'll just refer to the parties, Chemical and James signed a construction contract providing for James to perform over $500 million in civil and mechanical construction work, owned by Westlake. Although Chemical signed the contract in its own name, Vinyl's authorized Chemical to sign it on Vinyl's name, and the jury found that Chemical was acting as Vinyl's agent in entering into the contractual relationship.
Can you point us to some evidence or something in the record that indicates that there was some sort of agent relationship involving RHC and RHB? Where would we look for that?
The Royce Hassel affidavits, which are attached as oral argument exhibits.
Are they in the record?
Yes. Well, the Royce Hassel affidavit that's Exhibit 1 is in the record. The Royce Hassel affidavit that is in Exhibit 2 is in the motion for summary judgment in Springwoods 1, of which the trial court was asked to take judicial notice, and I can give the court the specific cite to the record where the court was asked to take judicial notice of the summary judgment motions.
I'm sorry.
Did they? They were asked to take judicial notice, did they?
The court was.
No, but did they take judicial notice?
The trial court?
You said they were asked to. Did they say, yes, we will take judicial notice?
Well, they didn't say no.
Okay, that's a legitimate question. I mean, you can ask.
Put it in a pleading.
Well, a trial court can say no. A trial court can say
no.
no. Okay, I'm just trying to figure out. I might be behind my colleagues here, but there's a gap for me here, a sort of a gap that I'm trying to tie you together with these appellees, and I'm struggling. So I'll let you continue with
Your Honor, on that very question, and this is the problem with this case. There was fraud involved in the sense that part of the owners of HCCI and the R. Hassel companies were not aware that the part of the owners of HCCI were taking direction from the district's director. They did not know when they attended that first mediation on July 2nd, that sitting in the room, in the one side of the room, were HCCI owners who were not being represented by the district's director, and HCCI owners that were. In fact, the appellants didn't discover that fact until December of 2015, when documents were produced in the bankruptcy court. And so there was.
Can you explain that? Because as I see the briefs and I see the pleadings, I'm a little unclear as to exactly what the fraud allegations, because to be frank, I think they kind of have changed a little bit. And so I'm trying to really get an understanding of what exactly is the fraud. I understood it originally when I first read it, when I read the briefs, my understanding was the fraud is that there were change orders that significantly increased the scope of the project that caused significant damage to the appellants. But now I'm hearing, can you explain it a little bit so I just have more of a clear picture?
those were contract claims, and this was a continuing contract, and it did require you to assert claims as you continued performance. Following the July 2nd mediation, the R. Hassel equipment, laborers were out on the project for many, many more months, and they were running into different problems than the delays associated with improper plans. For instance, I think they had dirt quantity claims, they had
Where were the knowing misrepresentations of material fact? I mean,
okay.
that would be the element of fraud. So
So-
I'm just trying to piece together this narrative. There are fraud claims, but I don't really
Right.
understand what the material facts that were knowingly misrepresented.
So it was a case within a case, because when the original lawsuit was filed, it was filed thinking that they were straightforward construction claims. You know, there was bad plans, the independent decision-making mechanism of the engineers failed
Right.
because
but
they.
when did the misrepresentation occur? Where, or just,
And so it was misrepresented that they would render a decision. But the fact of the matter is that there was not
okay, that's
going
not
to
a
be
that's not a presently existing fact, right?
Yes, but they attended the mediation as though they were mediating in good faith. There was no good faith in the mediation because, Your Honor, the mediating people were all on one side. In other words, the owners of HCCI were taking direction from the district's director. He was privy through them to all of the files and negotiations and statements and positions of the parties from the contractor's point of view.
But Ms. Hassel, didn't Mr. Hassel, in the October 2014 affidavit that you asked the trial court to take judicial notice of, Mr. Hassel talks about the fraud and talks about the fact that he had discovered that fraud by July 2nd when the mediation occurred. I think it's paragraph 11, 12, and 13 of his affidavit, where he very clearly states what the fraud was and when he discovered it.
Your
Was
Honor.
there something else that happened after that would form the basis of any fraud claim here?
Yes, Your Honor. Yes, Your Honor. Because what was discovered about the frauds came in two stages. It's a very detailed, fact-intensive thing, and fraud vitiates all things. I will say you don't know what's happening to you sometimes. What he discovered in September or so of 2013 is that Mr. Rose had begun representing Hassel Construction Company. He discovered in 2014 that Mr. Rose had taken over the plaintiff's side of the Springwoods lawsuit.
Mr. Rose is not a party to this lawsuit, though, so the
No,
fraud
he's the
claims
district's director, I'm sorry.
Okay.
The district's director. And that his knowledge is imputed, Your Honor, to all of the parties, because he's a director and a manager of the district, and you know, he's presumed that he's telling them what he's doing. And then the third discovery that occurred, Your Honor, so the first discovery was, well, Hassel Construction has gone and hired Mr. Rose's firm. Well, that requires a disclosure under the law of conflicts disclosure. That was not done. We called and asked him to withdraw, and you have to follow your conflict disclosure. That did not occur. The next thing that happened is that the lawsuit was commandeered. And if you look at the two counterclaims that were filed by the Springwoods and District in Springwoods 2, which is the only case in which they filed counterclaims, they admit in those counterclaims that the problem that happened in Springwoods 1 is that the Springwoods 1 lawsuit had to be wrested away from Royce Hassel and the R. Hassel companies, and that participating in doing that was the district's director.
So do you have, so when, what, I'm looking back at your brief and trying to come back to exactly what was briefed. When did the fraud claims accrue? What is your argument on that?
Well, I think different frauds accrued at different times because, again, there's one further discovery made in February or March of 2015 that representation that we thought was discovered in September of 2013 had been ongoing from January of 2012 without our knowledge. And so, for sure, the mediation wasn't ever going to be in good faith because the 99% owners of the claim were unaware that the 1% or owners of the 1% of the claim were negotiating with the district to commandeer the claim, which is what the counterclaims of the district and
So is that the moment that the legal injury was suffered? No, the cause of action would have accrued?
in 2015, you're saying March of 2015?
Well,
Is
I guess
that the-
I'm asking you. When,
Well, I think-
when would the first legal injury accrue?
I think the legal injury accrued, Your Honor, if I could pinpoint it, was when the lawsuit was wrenched and a friendly lawyer ultimately co-counseled to Coach Rose became the counsel for the HCCI that was there.
Isn't that just a dispute between HCCI and control of it and how they were managing? How is that a fraud claim against Springwood?
Ordinarily, Your Honor, that would be right if two shareholders are disputing, but it's not a dispute between two shareholders when the corporate counsel of that corporation, which is having disputes, is also a director for the district. That's not a shareholder dispute, and they are a control person of that corporation.
And that would be Mr. Rose? The
Mr.
director for the
Rose,
district is...
his law firm, and
Right.
yes, ma'am.
Are there any further questions from the panel? Yeah, well, thank you for your argument. Because Ms. Hassel went over a little bit, we'll give you each 3 minutes instead of 2.5.
Well, that will make a dramatic
Salt
difference.
Monica decision coming
Thank you
forward.
so much. Because I knew I had at least 3 minutes here and 2.5 wasn't going to work. So the last question and answer really highlights so many difficult issues in this case. And so when you get down to, whether or not the Voice Hassel companies can say that they were the principal and HCCI was really an undisclosed agent, well, the parole evidence rule is going to prohibit any evidence that's going to contradict the terms of the unambiguous contract. The economic loss rule is going to require that they only have claims to the parties that you contracted with in this context. All of that is extraordinarily troubling, but the issues that are before the court today are limited to statute of limitations. All those other issues are not going to go away unless this court affirms. But today the issue is statute of limitations. And we've established limitations by virtue of the legal injury rule. It applies to the contract claims, it applies to the tort claims, it applies to the derivative claims, it applies to all of them. And so the claim then is, okay, well, they want to argue the discovery rule. Well, they didn't bring that up at the trial court. They should have alleged the limitations was told by the discovery rule. They didn't until after the summary judgment hearing. So that allegation was not properly before Judge Moore, who, by the way, decided the summary judgment in the second case as well. So he decided both summary judgments. And respectfully, it's not properly before the court now, nor are any of the other 15 to 18, maybe 20 other tolling theories that have showed up in the briefing. The only one is whether limitations was told by the first lawsuit. But if we're going to talk briefly about the discovery rule, the discovery rule is not getting into discovering when Coach Rose did something. I can't even follow this whole dialogue. I've been struggling with it for a decade. A decade. This case was mediated, and 1 month from now, a decade ago. That's how long these issues have been going along, and these same kind of whack-a-mole claims keep getting asserted. But the discovery rule doesn't talk about when you discover whatever it is they want to talk about. It's when you discover your injury. If the discovery rule applies, limitations is told until the aggrieved party discovers or by the exercise of reasonable diligence should have discovered his or her injury. And it's clear from the claims that were made, the claims that were filed, all of those injuries occurred.
But it's your position that we don't even have to know what the discovery rule is because it wasn't
Correct.
presented to the trial.
Correct. But if we're going to talk about the discovery rule, it's clear the claims were discovered. So here in the supplemental statement of facts, the court granted leave to file the supplemental brief, or file a supplemental brief. Here they allege on page 2, by this appeal, appellants seek reversal of the trial court's summary judgments on limitations which occurred in a continuation case originally filed in July of 2012. They're referring to this case as a continuation case of the case filed in July 2012. The fact that they discovered their injury is really beyond dispute. Even if it's properly before the court, which it's not, it's really beyond dispute, and it's established as a matter of law. Now, this is a story of
Your time is up. I think your time is up now.
Excuse me.
Any questions from the court?
Thank you.
Thank you for your argument. Mr. Bell?
All right, thank you, Your Honors. Just a few points. First of all, on the contract, not a single argument raised by Ms. Hassel or the appellants was briefed against Walter P. The only briefing about the summary judgment on the breach of contract issue was found on pages 24 through 26 of their brief, their opening brief. And all it has to do with is alleging that it was improper for Walter P. Moore and Costello, the other parties, to jump onto Springwood's summary judgment briefing. That's the only argument that was raised. Nothing about there was a contract or here's the reasons why that summary judgment was wrong as to the contract or specific contract terms. That issue was never raised. She can't fix that here in oral argument today. We raised that point in our brief. There was no response to the point being raised in our brief, no request for permission for a supplemental brief. So the law is clear that issues were closed. Second of all, we were talking earlier about, there were some questions about what the contractual resolution mechanism was, whether they were forced to file a lawsuit, whether all they had to do was file notice. On page 607 of the record is a page of the contract titled Article 16 Dispute Resolution. And 16.01 says Methods and Procedures. And under C3, C is the provision that talks about the automatic termination or binding decision within 30 days of mediation failure. Unless, and the third option is, the contractor, the owner, gives written notice to the other party of the intent to submit the claim to a court of competent jurisdiction. So the contract did only require notice, it did not require actually filing the lawsuit. So the last point I wanted to make was on bankruptcy tolling. We think it doesn't apply because it was not pleaded. The Texas Supreme Court and even this court's recent opinions have stated that you only have a duty to negate the tolling doctrines that are pleaded. You don't have to anticipate tolling doctrines, you don't have to believe or negate other tolling doctrines, you only have to raise the ones that are pleaded. And bankruptcy tolling only applies to claims that are being made against a debtor, right? So only claims that are being made against a debtor are automatically stayed. The Fifth Circuit and the courts of appeals in Texas have all said that affirmative claims or claims being prosecuted by parties that are in bankruptcy aren't stayed. You can still try to pursue your lawsuits while you're in bankruptcy so long as there are not any claims being made against you in those suits. So the automatic stay doesn't stay or toll anything for the affirmative claims that are being made by the parties in this case. And so with that, Your Honor, unless there are any further questions, I'll yield the balance of my time.
Questions? Thank you very much.
Thank you, Your Honor.
Trials number 01-17-00822, CV, House of Construction Company, etc., versus Springwoods Realty Company, etc., is submitted, and the First Court of Appeals is now adjourned. Thank you.
All rise.